Hi, good morning to Dr. Rizal and my fellow friends. Okay, so today I'll be discussing on the tutorial question that's given to me. Okay, so in our this following is my tutorial question. Di dalam case Dean against public prosecutor, Lord President Thompson menyatakan, but the desirability for corroboration of the evidence of the prosecutor in the rape case springs not from the nature of the witness, but from the nature of the offence. Never it has been suggested that the evidence of a woman as such invariably call for collaboration. Okay. If, however, if she complains about having been raped, then both prudence and practice demands that her evidence should be corroborated. Mengapakah terdapat pendekatan berbeza terhadap keperluan keterangan sokongan dalam kes begini? Bincangkan dengan merujuk kepada kes-kes yang berkenaan. Okay, let me summarize what has happened in the case against Dean, in case of Dean against PP. So in the both case, it was laid down that corroboration is desired for the evidence given by the victim of a rape case or sexual offences case, and the need for corroboration is not due to the nature of the witness, unlike in the case of child witness or accomplice witness. Okay, but it's because of the nature of the offense. Okay, now before we move on in discussing what is corroborating evidence, we'll first need to establish what is known as rape. Okay, rape is criminalized under section 375 of the Penal Code and is punishable under section 376. Okay, there are various themes of rape, under 375, but we only focus on the two elements of the rape. Okay, first, there's sexual intercourse. Second, that sexual intercourse has occurred against the victim's will or without her consent. Okay, moving on, we'll discuss what is known as corroboration. Okay, in the landmark case of federal court case, Army against PP, it was defined, it defined corroboration as in the legal sense, connotes some independent evidence of some material fact which implicate the accused and tends to confirm that he is guilty of the offences. Okay, corroboration in this case needs to lead link to the elements need to be proof of rape in a rape case. For example, first, there's sexual intercourse, or second, that sexual intercourse is occurred without the victim's will or without consent. Those corroborated evidence has to link to that two particular elements, in order for it to be considered as a corroborative evidence. All right. Now, before we considering the necessity of corroborating evidence in rape case, that particular victim or prosecutrix, must be deemed as reliable, before corroborating evidence is needed to support her evidence. In the case of Nasrul Anwar bin Abdul Samad against PP, in that case, it was found that the complainant's evidence was vague and unreliable. So even though there are corroborative value in some supporting evidence, but it is not to be considered because in the first place, those corroborating evidence cannot support the unreliable evidence of the victims herself. So in other words, before we considering corroborative evidence, the victim's evidence itself must be reliable in the first place. All right. Now moving on, in the case relating or involving rape, usually there are injuries. So you might ask, how about medical reports? For medical reports or medical evidence, we have to look into it very carefully. So in this case of James against R, it was held that medical evidence showing that the complainant had sexual intercourse at time consistent with the allegation is incapable of affording corroboration of the complainant's evidence of rape. So let's say there are medical evidence that states that there are injuries on the hymen. So that particular report cannot be itself to show that it is of complete corroborating evidence to show that they are rape, because that medical report itself only shows that there are sexual intercourse. But how about the second element, without the victim's consent? So that part needs corroborating evidence as well, and that medical report cannot use to show that that particular intercourse was conducted without the victim's consent. So that medical evidence can only be used to support the first element, but not the second element. All right. But however, in the special case of statutory rape, which means that rape against minors, there in that case, consent is not to be consent is irrelevant. So in that case, medical evidence that shows that there are sexual intercourse itself can be sufficiently used to corroborate the evidence they are rape. This can be shown in the case of Sheikh Abdul Tahir anak lelaki Muhammad Ismail against PP. In this case, sexual intercourse was committed by the accused against the victim, who is actually a minor. So in that case, the learned judge did not have to decide on the question of consent as the victim itself was under the age of 14 at the material time, and therefore the consent was immaterial. How about medical reports or sorry reports that shows there are seminal stains. Okay, seminal stain itself is not vital in order to prove rape, but however, that particular report can be used as a corroborating evidence. Okay, in that case, in this case, Razi bin Amin against private prosecutor, the presence of spermatozoa or seminal stain can be used as corroborating evidence that shows that they are uh there are sexual intercourse committed. But however, don't forget we need to still fulfill the second element, okay, where there is without consent. Alright. So in another case of Chiu Nang Hong against public prosecutor, okay, this is the case of privy counsel. Okay, it is possible to convict based on uncorroborated evidence of the complainant alone, provided that the trial judge has in mind the risk of convicting based upon such uncorroborated evidence. It is possible, but the judge or the trial judge must be very cautious. Okay, the judge should also state very clearly that he has in mind that risk, but he is nevertheless convinced of the evidence, though uncorroborated, that the case against the accused has been established beyond reasonable doubt. Alright. Okay, now moving on to the case of Ahmad Nazri against Abdul Majid against PP. Okay, in this case, it refers to the previous case just now. Okay, where the trial judge has committed without uncorroborating evidence. Okay, and that judge actually stated, okay, the reasons. Okay, in the instance case, the trial judge had noted in the ground of judgment that she has cautioned herself on the absence of corroboration and went on to find that there was no reason for the victim who had not known the accused to make a false allegation against him. Okay, in another case of Zuki bin Muhammad lawan pendakwa raya, okay, it also stated that corroboration is desired in sexual offences, especially where the complainant has not reported within a reasonable period or in the first available opportunity after the incident. This also shows that the under the Evidence Act Section 8, which is to show the conducts, okay, it is desirable to have corroborating evidence. However, in the event where the victim uh in the event that the victim, for example, has doubts, okay, or the corroborating evidence does not support, okay, the statement that she claims that she is being raped, then there will be doubt raised in the judge's minds. For example, in this case, okay, there was no reasonable explanation given by the victim why she only report to the police station to make a police report 44 days or around 6 weeks after the incident. So this has raised a doubt on the judge mind. Okay, and this particular evidence does not support, okay, that she's being raped. Okay, next moving on to the case of Ahmad Faisal Ali bin Audat Ali. Okay, in this case, for the supporting evidence, okay, let me show the next case will show the examples of what are to be considered as corroborating evidence. Okay, in this case, the trial judge has relied on the police report lodged a few hours after the incident, and not only that, the evidence given by the medical doctor who examined the victim. Okay, that police report can be show at the fact that the victim made the police report can show can be a corroborating evidence that that particular sexual intercourse was committed without her consent, and the evidence given by the medical doctor also can be used as a corroborating evidence that there was sexual intercourse conducted. Okay, next, in another case of Tengku Ahmad Hanif bin Tuanpa lawan pendakwa raya. Okay, in this case, the victim, through her testimony, has described in detail that there was penile penetration. And not only that, the victim's description was very solid and extremely probable and unusually convincing. And therefore, it was held by the court that the victim evidence could stand on her own without even the need of corroborating evidence. But however, it was bear in mind that in this case, the victim was actually a minor. But however, the court actually has also laid down a few examples of what corroborating evidence has been adduced, and those evidence can actually be used as a corroborating evidence in the event where the victim is not a minor. Okay, in that case, there are a few evidence that can be used as corroborating evidence. First, SP5 evidence confirmed that there was an old tear and a hymen caused by the stab of a blunt object, such as the male penis. Okay, this shows that there was sexual intercourse. Second, the evidence of SP being the first person to be informed of the rape incident. Okay, the fact that the victim told another person that she is being raped, okay, shows that that action is it becomes a corroborating evidence that the sexual intercourse is done without her consent. Okay. Third, the evidence of SP1 stating that the victim told him that the victim was raped by a friend he knew in the hotel. Okay. Another one, okay, she told another person. Okay. that action herself also shows can be used as a corroborating evidence. And fourth, the evidence of SP4, which is supported by his police office confirming the occurrence of rape against the victim. Like I say, okay, the fact that she made a police report, okay, can also be used as a corroborating evidence. Okay, so another case, back to the case that we discussed in the first place just now, which is Dean against public prosecutor. It's a quite an old case, 1964. Okay, but in that case itself, it's actually the principle of corroborating evidence was actually referred to an even older case, okay, known as R against Baskerville, 1916, or famously known as the Baskerville case. Though in that case, the court actually laid down principles regarding on corroborating evidence, including child witness, accomplice, and also in that and also other scenarios where it requires corroborating evidence. So in the case of Dean against private prosecutor, it was the contention of the appellant, okay, that in every rare case it is a rule of practice and prudence, taught no law, that the trier of the fact, in this case the judge, should be warned or should warn himself of the danger of committing in the absence of corroboration. In that case, it was a contention of the appellant. It says that in rape cases, the evidence of the victim needs to be corroborated in the first place, okay, and that the appellant actually relied on the case of Baskerville case. But however, in that case, the federal court actually dismissed the appellant's appeal, as there are corroborative evidence in support of the victim's evidence. Okay, first in that case, okay, the trial judge actually found that the victim's evidence was actually supported by the presence of seminal stain on her bed, on which she had been lying, and the trousers she has been wearing. Okay, secondly, the medical report stating that the victim has sign of injury on her neck. Okay, so the first evidence shows that they are sexual intercourse. Okay, and the second evidence, okay, in this case, the medical report, it's not a medical report stating that she has a tear in her vagina, but however, it is to state that there is injury on her neck. That particular injury shows that, okay, there has been struggle, okay, there has been rejection there has been rejection on that particular sexual intercourse, okay, and that injury shows that, okay, that particular sexual intercourse has been done without her consent. So these two evidence, okay, supported the first element and the second element of the rape. So in the conclusion of this whole tutorial, okay, so it has been stated that the need for the corroboration of the victim evidence in the sexual offences case is a matter of practice and prudence. Okay, unlike child or accomplice witness, okay, the need of the corroboration of the victim evidence in the sexual offence actually spring not from the nature of the witness. Okay, unlike child witness and accomplice, where the court has to be careful on the witness because of the nature of the witness. But in the sexual offences case, not because it is the victim's evidence is not reliable, but however it's because the nature of the sexual offences itself. Because in sexual offences, usually in the trial it boils down to an oath against another oath, which is the testimony of the victim against the testimony of the accused that say that she is consented against the act. So it's an oath against an oath. Therefore, the necessity of the corroborating evidence towards the evidence of the rape victim. So in the case of PP Amran against Nasir, okay, it was shown that the judge also stated that, okay, the court needs to be very careful, okay, in listening to the victim's case, because usually there are also scenario where the female or the victim actually accused, okay, accused of rape, okay, due to a certain reason such as jealousy, spite, or the girl refusal to admit that she has consented to an act against she is now ashamed. So in the final conclusion, the right for the approach of the court is to analyze evidence for the prosecution and for the defense to decide whether the complainant evidence is so reliable that a conviction based solely on it is not unsafe. Okay, so like what I say, okay, it is desirable, okay, it is best if there's corroborating evidence. But however, if in the event there's uncorroborated evidence, the court can still convict, okay, without corroborating evidence. However, there must be a very strong, okay, evidence, okay, or circumstantial evidence that shows that, okay, there's indeed, okay, rape occurred, okay, and that rape or that particular sexual intercourse has been committed without her consent. Okay, so that's all from me. Okay, thank you very much for listening. Okay, wish you all have a nice day. Thank you.